Everyone, welcome to World of E-Education. We are going to read the current affairs of September 2025 from Vision magazine. Let's start. 1. Polity and Governance 1.1. Criminalization of Politics. A report by Association for Democratic Reforms, ADR, has found that about 47% of ministers in India, including in the Union Cabinet and state cabinets, have declared criminal cases against themselves, out of which 27% are of a serious nature. Causes of criminalization of politics. Criminalization of politics refers to the entry and participation of persons with criminal backgrounds in the political and electoral process. The causes include politico-criminal nexus. Criminals enter politics to gain immunity and legitimacy, while politicians and parties use them for their muscle and financial power, creating a vicious cycle of mutual benefit. Vora Committee Report 1993 highlighted the nexus of politicians, criminals and bureaucrats in the Indian administrative and political setup. Winnable candidates. ADR data 2024 indicates that the success rate for candidates with criminal charges was 15.3%, while candidates without any criminal cases had a much lower success rate of just 4.4%. High cost of elections. To fund election campaigns, candidates and parties often rely on black money and funds from the mafia. Slow justice system. Poor conviction rate for MPs and MLAs, coupled with trial delays, does not deter political parties from giving tickets to candidates with a criminal background. 55% rise in MPs with criminal records since 2009, ADR Report 2024. Identity politics. Elections often prioritize caste, religion over criminal records. Constitutional and legal provisions to reduce criminalization of politics. Representation of People Act, 1951. Disqualification under Section 8. Individuals convicted of heinous crimes or sentenced to 2 years or more face disqualification. Section 11 gives the AG the power to remove or reduce the period of disqualification. This power was utilized in September 2025-2019 to reduce the disqualification period of Prem Singh Taming. Recent initiatives. 130th Constitutional Amendment Bill seeks to amend Articles 75 and 164. It proposes that a minister arrested and detained for 30 consecutive days for an alleged offence punishable with imprisonment of at least 5 years shall be removed from office. Way forward. Enhanced penalties for false affidavits. The punishment for filing false affidavits, recommended by 244th Law Commission Report, 2014, should be enhanced to a minimum of 2 years imprisonment, and this offence should also be made a ground for disqualification. Dedicated election benches. High courts should set up dedicated election benches to hear petitions through day-to-day trials, ensuring timely convictions before disqualification of candidates. Review of Section 11 of RPA, 1951, convictions for serious crimes should be kept out of the Election Commission's power to reduce the period of disqualification. Financial and transparency reforms. Political parties should be brought under the RTI Act, 2005. 1.2. Judicial pendency. Case backlog in Supreme Court hits all-time high of 88,417. More in the news. District courts have nearly 4.6 crore pending cases and high courts have nearly 63 lakh case pendency, National Judicial Data Grid. Reasons for pendency of cases. Inadequate judge-population ratio. India has just 21 judges per million people against the recommended judge-to-population ratio of 50 judges per million, 120th Law Commission. Ineffectiveness of alternate dispute resolution, ADR. ADR mechanisms have not been deployed effectively enough to meet the rising demands for justice. Gram Nyayalayas, village courts, which were proposed to handle small claims in rural areas and reduce the main judiciary's workload, have not been effectively established in most states. Systemic and procedural inefficiencies. Judicial delays in India stem from multiple appeals, frequent adjournments, frivolous litigation, vague laws, weak compliance and poor case management. There is often no systematic grouping of similar cases or categorization based on urgency, leading to inefficiencies. Deficiencies in judicial infrastructure and technology. India's judiciary faces challenges like shortage of support staff, lack of basic amenities in lower courts, limited technological equipment and poor digital adoption. Financial constraints. India spends only 0.1% of GDP on judiciary compared to 2% on defense. Government is litigator. Government agencies are responsible for around 50% of litigation. Impact of judicial pendency. Violation of fundamental rights. The Supreme Court in Haseinara Khatun vs. State of Bihar, 1979, held that the right to speedy trial is part of Article 21, right to life and liberty. Social implications. Weakening rule of law. Delay in criminal trials emboldens offenders and reduces deterrence. Disproportionate impact on the poor. Industrial prisoners. About 76% of prisoners in India remain incarcerated without conviction. Economic implications. Increased litigation cost. Parties spend heavily on repeated hearings, adjournments, and lawyer fees. Stalled projects. Land acquisition and environmental clearance cases block infrastructure development. Erosion of trust. Citizens lose confidence in the judiciary and sometimes resort to extra-legal methods for dispute resolution, black court syndrome. The delay in delivering justice has become so systemic that it can be perceived as a new defense, where prolonging a case becomes a strategic advantage for one party. Schemes, initiatives by government to reduce case pendency. National Mission for Justice Delivery and Legal Reforms, NMJDLR 2011, reduction of arrears and delays, infrastructure, procedural reforms. Centrally Sponsored Scheme, CSS, for development of infrastructure for judiciary, court halls, residential units for judges, lawyer halls, toilets, digital facilities in courts. E-Courts Mission Mode Project, Phase 1, 2, 3, computerization of courts, e-filing, video conferencing, virtual courts, virtual justice clock, justice app for judges. Commercial courts, under Commercial Courts Act, 2015, faster disposal of commercial disputes, lowering pecuniary jurisdiction, electronic case management. Fast-track courts, FTCs, disposal of long-pending and heinous criminal cases. E.g., near courts, POCSO courts etc. Alternate dispute resolution, ADR, mechanisms, settling disputes outside regular courts, reducing burden through Lok Adalats, mediation, arbitration etc. Way forward. Establishment of a central authority. The establishment of the National Judicial Infrastructure Authority, NJIA, as proposed by former CJI Justice N.V. Ramanna in 2021, is needed to plan, create, manage, and maintain functional infrastructure for Indian courts. The potential of AI in case management should be explored. Appoint ad hoc judges. Articles 128 and 224A of the Constitution should be invoked to appoint experienced retired judges as ad hoc judges in the Supreme Court and High Courts. Setting targets and timelines. High courts and subordinate courts should set annual targets for disposing of old cases and conduct bi-monthly or quarterly performance reviews to ensure accountability. Controlling adjournments. The practice of granting adjournments on flimsy or technical grounds, which waste significant judicial time, should be strictly regulated. Reforming litigation practices. Reduce government litigation, draft clear laws, ensure timely compliance, and deter frivolous cases. Prioritizing ADR mechanisms. Expand ADR and promote local resolution to reduce unnecessary litigation. The legal services authorities should undertake pre-litigation mediation on a large scale to regulate the number of new cases being filed. 1.3. National Medical Commission, NMC. The National Medical Commission, NMC, recently completed 5 years. About the National Medical Commission. Establishment. A statutory body constituted under the National Medical Commission Act, 2019, came into force on the 25th of September 2020. Replaced the Medical Council of India, MCI, and the Board of Governors was dissolved. The commission consists of the following persons to be appointed by the central government, namely: a chairperson, 10 ex officio members, 22 part-time members, 4 autonomous boards under NMC. Undergraduate Medical Education Board, Postgraduate Medical Education Board, Medical Assessment and Rating Board, Ethics and Medical Registration Board. Issues with NMC. Governance gap. Weak accountability due to a body dominated by doctors. It lacks public health experts, social scientists, or citizen voices. NMC also allows appeals only from registered medical practitioners, systematically rejecting patients' complaints despite no legal bar. Fee regulation. Controls fees for only 50% of private seats, others remain prone to exorbitant charges, excluding poor students. Ethics oversight. Misconduct cases handled without judicial expertise or timelines, raising concerns of impartiality. National Medical Register (NMR). The process for updating and verifying the credentials of practicing doctors in the NMR has been very slow, leading to concerns about unqualified individuals practicing medicines. Conclusion. While the NMC marks a step towards modernizing medical governance in India, addressing concerns of accessibility, ethical oversight, and inclusivity remains vital to build a transparent, accountable, and globally competitive healthcare system. 1.4. News in Shorts. 1.4.1. Indian and French political systems. Recently, the French parliament voted to remove the government along with the prime minister, creating political instability in the country. Comparison between the Indian and the French political systems. Similarities. Republican form of government with elected heads of state, bicameral legislatures, based on the principles of democracy, emphasizing liberty, equality, and fraternity. Differences. Refer table. Aspect. India, France, constitutional model, parliamentary republic, single executive led by PM, president largely ceremonial. Semi-presidential with dual executive, i.e., president plus prime minister. Procedures to elect the president. Indirect election by an electoral college using single transferable vote and secret ballot. Direct election by universal adult suffrage. Choosing, removing Prime Minister, PM. The PM is elected by Lok Sabha and must retain the confidence of Lok Sabha. The PM is appointed by the President, but must keep Assembly confidence. Federal design. Quasi-federal, blends federal and unitary features. Unitary, centralized authority with local governments as central agents. Approach to secularism. Positive approach, state maintains neutrality but can intervene to reform, e.g., abolishing untouchability. French laicite enforces strict separation of religion and state, e.g., bans on conspicuous symbols. 1.4.2. Vishakhapatnam Declaration. The declaration adopted at the 28th National Conference on E-Governance called for a whole-of-government approach to strengthen civil services with digital competencies and agile and data-driven frameworks. Key proposals of the Vishakhapatnam Declaration. National vision, inclusive, citizen-centric, and transparent governance. Technology-driven governance, adoption of AI, milliliter, blockchain, GIS, IoT, and data analytics to deliver multilingual, real-time, and sector-specific citizen services, emphasizing the need for ethical and transparent adoption. E.g., Digital India Bhashani, Digi Yatra, NADRES V2, etc. Replication of successful models. Focus on nationwide scaling of models like Sampada 2.0, MP, Ekhata, Bengaluru, Rohini Gram Panchayat, Maharashtra, Drone Analytics Monitoring System, DAMS, by NHAI, etc. Grassroots and inclusive development. Geographical outreach to regions with connectivity challenges, like Northeast and Ladakh, under the NESDA framework. Nationwide expansion of successful Panchayat digital models, launching digital literacy programs targeting women, youth, etc. Cybersecurity and resilience. Focus on zero trust architecture, post-quantum security and AI-enabled monitoring in priority sectors like transport, defense and citizen services platforms. Agriculture and sustainability. National Agri-Stack for better access to credit, advisories, and markets. Other. Collaboration between government, industry, for scalable digital solutions, regional hub development, e.g. Vishakhapatnam as IT and Innovation Hub. Related news. World's first AI minister appointed in Albania. Dialer, an AI-generated bot will manage and award all public tenders for government projects, aiming to enhance transparency and minimize corruption. 1.4.3. Immigration and Foreigners Exemption Order, 2025. Union Ministry of Home Affairs notified the Immigration and Foreigners Exemption Order, 2025, under the Immigration and Foreigners Act, 2025. 9 key highlights of the order. Exemption of passport visa for Indian Armed Forces on duty, Indian, Nepali, and Bhutanese citizens at specified borders, Tibetans with valid registration and special permits, specific religious minorities, Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians from Afghanistan, Bangladesh, Pakistan who entered by December 31, 2024, even with invalid documents, and registered Sri Lanka Tamil nationals who took shelter by January 9, 2015. Visa exemption also applied to foreigners holding diplomatic, official passports were waived by agreement. Those eligible for visa on arrival. Certain foreign military personnel visiting on naval warship.